Good morning, everybody. Welcome to our 35th edition of Cannabis Live. I'm Craig Aronoff. Along
Travis
with
Copenhaver.
Good
morning.
Welcome to our Cannabis Live. We do this every Friday morning. We're talking all things to do with the medical marijuana market here in the state of Michigan. We're with the Cannabis Legal Group in Royal Oak, Michigan. We have on our page here a link to our municipalities page. We have a map there that we've often talked about that could help people determine which communities have opted in and opted out, and those that would be interested in dealing with the facilities in their community. Please like us, share us, ask questions. We want to be engaged throughout this. So our best way to help inform people is by answering questions. So we'll do our best to answer them live or by email or text afterwards. But certainly we appreciate the opportunity to engage the market. Today we're talking about something that's kind of exciting to us wonky people here in the mud and MMFLA. It's something that we've been waiting a long time for. This is an amendment, a technical fix to the law here in Michigan that we've known about for some time. I think it went to the House, back in October or something?
Yeah, right around October, I think it's
Yeah, and so we've been waiting for it to get progress, and as we understand it, they've reconciled with the Senate, and there's a bill present on Governor Snyder's desk to be signed, and that's what we want to talk about today, because there's been a lot of things that we get asked commonly. For instance, well, if I have my facility for a processor and a grower in the same location, what's the question we get?
Why can't we just move it when it's harvest into the processor license?
Right.
Well, under the MMFLA, you need a secret transporter anytime products move it from one license to another.
Right.
Well, that's one of the main fixes. There's a lot of stuff in here, and we're going to kind of dive deep into how it's going to affect how these licenses are going to interact. And it's a great bill. Hopefully the governor signs it and it goes into law. Some of the emergency rules, as we'll talk about, basically anticipated that it would be law. So it's probably going to be something that's going to be a reality, but until the ink's dry, you never know.
Yeah, there's no question that this is something that as we look through the rules when they came out in early December, there were some questions about this 30-day period after licensure. What are they talking about? And in essence, the rules were almost in foresight saying this fix is happening in some form or another. It was, approved by Lara, and it was something that has been pushed by those of us in the industry, because the question of why should I put it on a truck to drive it out to the main road from my east store to bring it in my west store, and the added cost that would add to the marketplace just simply made no sense once Lara came out with that bulletin for co-locating. And now all of a sudden we know that was their intent. And so within this rule set is the ability now for a co-located facility, and it doesn't necessarily have to be the same licensee. It's a co-located facility. Two separate licensees need not have to use a secure transporter if they're not going out on a private road.
Yep,
so that means industrial parks.
Yeah, if you're lucky enough to be next to on the same parcel, or even in a private maybe set of parcels, as long as you're not on the public roads or highways or whatever you need, you can move products from one licensee to another, whether you control both licenses or not. Yeah. So if you're the grow and there's a provisioning center and you're in the same strip, guess what? If there's ways to move that product around without, getting it onto a sidewalk or a highway or a road, you're going to be able to do that. Yeah. You'll have to track it in metric. You're going to have to track it in seed to sale.
That is the rule.
So, it's not like you can avoid tracking requirements or anything, but you'll be able to, avoid that cost of bringing in a third company, the secure transporter, to move it from point A to point B.
So, let's I guess back up a little. We're talking about that's a specific provision. We'll get into it. Another question that we get often asked, and I'm really happy to see is cured in this technical fix is how do we start? Yeah. Or I'm a processor. Am I able to sell to other processors? And the answers are going to be yes, and at least in the second question. The first question is a little more complicated. But guess what? We are allowed to use marijuana plants. And so let's get into this a little bit more, Travis. Yeah, so first and foremost, on the caption and description that accompanied the posting for the Facebook Live, I added the links to both the legislature, and we added that so that you can go click on the act yourself, read it for yourself. Remember, everything we do here at the Cannabis Legal Group is try to provide not only the information, but the sources of information. As you look at our municipalities page, every single community is linked to their community as well as the ordinances themselves are there. Do your due diligence and review things for yourself. We're going to give you our opinion and impression of what these changes are, but we want you to have the opportunity to verify it. The second link that we included is a fiscal summary, basically an analysis from from the Senate agency that's like in the background giving an analysis to each of the senators for what they should be reviewing and the why it is they were proper to vote this in and approve it to move forward. So those links are there. Please verify and read it for yourself. Now, when we get into the mud here, as Travis and I go back and forth, please remember, ask questions if we're not clear on something. And feel free to engage us on it because we want to be as conversational as we can. It's actually a pretty robust change. It affects many different components of it. It's actually it's a 27-page document for the actual bill. Now a lot of the MMFLA was unchanged. But when you go through this bill, you'll see that they actually cross off the language that they're changing and add the language that they're adding in bold print. So it's easy to kind of find your way through it. The other thing is the summary does a really nice job kind of walking through the act. Now the top page of that summary you'll find is going to be basically a more updated Senate analysis, and then below it is a House analysis from a couple months ago. So make sure you know what you're reading on and that you try to stay as current as we can through it.
And just so you're all aware, this is very new. The House passed this, concurred with the Senate. The House was working on it in October. It went to the Senate. They passed it January 16th. The House had to concur on the 17th, and now we're waiting for it to take its final step, which is being approved by the governor. So it might be a few days until this is going into effect. Obviously the governor has to sign it. We're talking about something that just was happening earlier this week.
Yeah,
so it's new for everyone.
Yeah, and this is something that, when this came off we've been watching House Bill 5144 the whole time. So we've been waiting to see its progress. When we got wind that the Senate was going to approve basically a virtually unchanged version of it, the few minor technical things. But ultimately, that's when we kind of came to the conclusion, we really need to start talking about this a lot more publicly because as people are doing their business planning, there is a significant change that growers can do here. So let's just kind of go through it kind of the way that it's set up so that we're not skipping around too much. The first thing that the Act really does is it lays out a set of immunities. And we all know as caregivers and patients over the last nearly 10 years now, you were deemed immune from prosecution under state law. It didn't make marijuana legal. It just made it so that the prosecutors couldn't prosecute you. And so we had this immunity. And then in the MMFLA, they added a new immunity for landlords. And so if you're a landlord and you're leasing to a facility and you're unbeknownst to you that there's no violations, you're immune from any occurrence that could happen from the license. One of the things that's been happening, though, is the secondary thing in the Act required a CPA to attest to your financials, and many CPAs were worried, well, I'm participating in a federally illegal activity, and there's nothing in this Act that protects me. State, am I even allowed to do a CPA attestation? So tell us a little bit about how that was fixed.
Yeah, so effectively what they've done is wrote right into the MMFLA, if you're helping an applicant or a licensee completing the documents they're required to have attested to by a CPA, you're going to be protected by state law for engaging in this activity just like the applicants and the landlords would have been. It effectively says you're not subject to criminal, civil, or administrative sanctions for engaging in the practice of public accounting in the means of doing this for MMFLA hopefuls.
So, so in essence, it basically clears the path from a state perspective as to what your participation is. On a national perspective, again, those questions are still out there. I think if you've seen both Travis and I have written recent posts on, the Cole memo and what impact it may have on our industry. And I think the short answer to that is that we have little concern about what the federal, scrutiny would be for CPAs participating in the state activity. Oddly, though, if I may, as a professional licensee here in the state of Michigan, it doesn't say lawyers are given the same immunity, but we have other reasons to believe that that's the case, so we're not too concerned. I just think it's curious.
If you're lucky enough to be one of those CPA attorneys, maybe you're okay.
There you go. You wear both hats.
I'm not a numbers guy.
Separately, though, the next thing it did, and this is answering another significant question that we get all the time, and I get this publicly, like when I'm at every single public municipality meeting that I'm in, this question comes up, which is what about banking? Well, the state created a new immunity for financial institutions, in essence trying to encourage them to participate in this and eliminate any worry at a state level about that activity. So,
and I think you'll find from a national perspective, banking is always the challenge. It's a challenge in any one of the medical marijuana states throughout the country. And there are a lot of challenges. Michigan isn't in a position to correct because there's federal protections and federal implications for the way banks operate. However, this amendment to the MMFLA makes it very clear that if you are a financial institution in the state of Michigan providing financial services to licensees, you are not going to be subject to penalty under the state laws of our state.
That's right. And so, and then the type of activities we're talking about is taking deposits, doing withdrawals, transferring between accounts, exchanging currency, giving loans or extensions of credit, purchasing stock or stock certificates, CDs, any other account transfer, or using other monetary instruments. In other words, all the regular banking activities that a state chartered bank might be inclined to engage in, the cannabis industry is available under Michigan law to do it without, concern of penalty due to this immunity shield that's set up. Now remember, you have to be acting compliantly. And so the immunity doesn't say, hey, we just can do anything we want. You still have to go through whatever checklist of items to remain in compliance with your banking requirements under FinCEN's guidance and those others. But again, this clearance and this immunity, we're hoping will allow these, more conservative bankers to maybe say, all right, that's one less thing to worry about. Now let's really engage the industry.
And there was always this, big national banks, probably not the bank for you, but there was always, credit unions and smaller intrastate banks that were willing to provide some banking services to this industry. And what this is doing is making it very clear, if you're that type of financial institution, you don't have new concerns from the state law that has changed. The MMFLA provides those protections to you too. Now, you can't help any industry, use your bank to commit some sort of crime or fraud. And that's obviously not something you can do here. But if you're compliant with the MMFLA as an applicant, as a licensee, and you're working with a bank, the bank is going to be covered from helping provide you those services.
Correct.
And financial institution is broad as well. It's not necessarily just banks and credit unions. It also, applies to things like insurance company issuing you an insurance policy, which you're required to have,
Right.
and some other activities as well.
Yeah, and so again, what the technical fix of the act is it basically engaged and looked at. We knew going into this licensing phase, as Travis just mentioned, insurance is required. We knew going into this licensing phase that everyone needed to have it, and there's a professional services provider out there with a state license who would then be worried about engaging the activity. So what the state did in this technical fix is look at all the requirements that are put into this licensing and offered the immunities to allow all the professionals to do their business and really help keep this industry from falling on its face without the services needed to get it done. So that gets us through the first part of, I think, some of the kind of technical things. The next part, I think, is the part everyone would be most excited about, and that is the changes to the actual licensees themselves. And first and foremost is the most prominent one, and that goes to grower, and there's a specific definition change that I think is most crucial to everything that we're doing in the MMFLA. And what that gets into is, in essence, what do we do to propagate? And so, Travis, what is the new change, and what is that word that we're so excited to see in there? At least now we can use plants, right?
Right. So we have a couple. There's seedling. Is that the one you're referring to? Or
no, well, just in plants in general. So sorry.
Plants. I'm sorry. I wasn't following you.
No problem.
You had this great setup, and I blew it.
No, it's all good. So in essence, a grower from the onset, the original MMFLA basically said seeds or seedlings, and we've been gaining a lot of questions that people have had. Is first and foremost, well, what's a seedling? What about clones? We hear that a lot. What about my plants? What do I do with my mother plants? How do I protect my genetics? What about, making sure that those strains can survive, and how do I get those into a facility? If I'm a caregiver and I give up my license and I go work at a facility, what about the plants I had? What do I do? And so these open-ended questions that the MMFLA raised are answered in this amendment. And so that's really the technical fix that I was going towards, be so excited about.
So effectively now what you can do is, the rules contemplated this. Growers with active employees that happen to be caregivers When you're an employee or an owner of a grow facility, you have to stop being a caregiver once your license is issued to you. The big question was, what do you do with all the plants you've been cultivating for your patients? This amendment specifically provides an activity for how those caregivers, if they so choose, can bring their plants and materials into a grower's umbrella of its license. Effectively, you're going to have a 30-day window where former registered caregivers who are now active employees of a grower's license can bring in plants, seeds, and seedlings for that grower to then take in, enter into metric, and then use as your first round of plants for the grower to eventually go on and move forward in its cultivation activities.
So, and let's back up just a second and talk a little bit about what we're really saying with all that now. So, if you're a grower and you're starting off, the big concern was, well, what do we do with supply? If we start with a seed, we're looking at, on the short cycle, 5 months, probably closer to 8 months to get everything grown, cultured, cured, and then, tested and then transported into the marketplace. And so processors and provisioning centers wouldn't have any, purchasable supply for some time. Mm-hmm. What the technical fix says is that when you're bringing in those caregivers that happen to have mature plants, now they get to come in with those plants, and you could potentially have harvestable plants day 2, right, maybe even day 1.
As soon as
they're
tagged.
Right. So these relationship that grower licenses you should be pursuing is with the employees, caregivers, and encouraging them maybe to, manipulate their harvest cycles so that when you're licensed, you have big monster trees to bring in called marijuana plants. Right. Because remember, as a caregiver, you still have to maintain your supply limits.
Yeah.
So we can't harvest and sit on that supply greater than 2.5 ounces per registered patient. And so we want to be cautious about saying, like, if you're growing it, there's nothing that said you couldn't grow it really large. You just were only allowed to harvest 15 ounces, max with all of your registered patients. And so that's something I think is very keen. Now, how do we get it to the facility? That's another thing that people were a little bit worried about, because do they need to be on a secure transporter? Well, there was actually some language in there that kind of let us know what the state was expecting on that. So why don't you talk a little bit about that?
Right. So effectively, a caregiver is protected under the 2008 Medical Marijuana Act. A grower has to operate under the 2016 MMFLA. So when a grower is moving plants back and forth, if they're a licensed business, they have to use a secure transporter. That's right. Made very clear. A caregiver bringing something in where they used to be a caregiver and they're now an active employee, they're coming into the grower, has to move those plants the way 2008 says they do. So a caregiver, as long as they're transporting plants pursuant to 2008, can transport those plants in. Once the plants are under the ownership or control of the grower, a grower cannot move plants from point A to point B without a secure transporter, unless you're in the situation where you're co-located. If you're moving seedlings or seeds, you can move those materials without the use of a secure transporter. So what you have to do is become familiar with these new definitions that this bill is doing. So a seedling is more or less, the equivalent of, a small, recently starting out, what we would want to usually call clone, what we should now start referring our definition to the word seedling. If you're moving those materials around, or tissue cultures, which is another new term from this bill, that does not require the use of a secure transporter. However, the plant itself, something that doesn't fall into the subcategory of plant, which is seedling, needs to be moved from point A to point B by a secure transporter.
So I see that we do got a couple of questions. And Shane, we're going to get to yours in just a minute when we get to the processing licenses. Rick, you asked a question that, Travis and our new colleague Nick Melendez and I, we were discussing in advance of today's show, which is in essence, the patients are the one whose plants they are.
Right.
And so that's a relationship thing. So if you're a caregiver and you're seeking to now say, I'm going to take these plants that I've been supplying my patient who also has a stake in those plants, I would think that if they're doing it for the patient, so they're growing specific plants for the patient, they should be communicating to the patient, if you're going to take over the activity of growing for yourself, we can actually transfer those to you. On the other hand, if not, then my intent is to no longer be your caregiver anyway, because I'm going into a grower license situation, so I can't do both. And just so one way or the other, the caregiver is going to have to dispose of the plants in their possession. And the best choice right now would be to get them into the facility where their genetics are protected and can be used, or I guess in the alternative, pass them back towards the patient so they can continue to get their supply on their own behalf.
It's important to remember how 2008 works for patients and caregivers. And just briefly, you start out, I have a qualifying condition, I'm a patient. That allows me to cultivate up to 12 plants. If I'm unable, unwilling, or just don't have the time or incapable of doing that, I can assign that right to a caregiver. The caregiver can only grow those 12 plants with the permission of a patient they agreed to work together with. Now, in the scope of that relationship, if the caregiver has, up until this point, considered those plants the property of the patient, then that caregiver can't, join one of these growers as an employee and transfer the plants in without the patient's permission or purchasing those plants, etc., whatever that relationship is. Now, if your relationship between patient and caregiver has been one of, you've increased my plant count, I'll make sure you continue receiving your up to 2.5 ounces when you need it, medications, I'm going to have to stop doing that. If I've maintained the effective ownership over the plants I'm allowed to grow because you have been assigned as my patient, then maybe I still have the ownership rights to bring those plants into a grower license. So there's no one way or the other. It depends on the relationship between that patient and caregiver as to what's going to be allowed.
And somebody's saying no video. I don't know if that's true or not. It looks like we're live.
Let's see here. We can double check that just in case.
Yeah, that's kind of confusing. So I don't know why that would be the case. If that is, let us know. Yeah, it looks like we're on there.
Yeah, I think we're good. Sorry. It
might
just
Brad,
thanks for letting us know, Brad.
Right, make sure you know that your video is. And then,
thanks, Rick.
Yeah, thank you. We appreciate that. And when you say, is that unlawful to do, a caregiver to a non-connected entity violates the MMFLA. And I think that that's where this change happens. So it does say in the act that you have to be an employee of the grower in order to have those plants transferred to that grower licensee. And thank you, everybody. And as a result, I think that that's the differentiation, Rick, that you were concerned with. We're not just selling it to anybody. The way that the two laws, and I think what you're concerned with is something that the two acts do have some reconciliation language in there, because it does say you have to remain compliant under the MMFLA.
I would read that personally as the specifics overrule the generalization. Right? Generally, you're right. That's not a transfer the MMA allows you to do. However, because of the specific rules laid out in this bill in the statute, because specifically it says you could do that, while the MMFLA isn't protecting you for that activity, the MMFLA would be.
Right, and you're no longer a caregiver at that point.
Right.
And so, and I think that that's one of the other things. So it's actually written in there to presume that as you transfer in your caregiver license in exchange for that employee license at the grower facility, in essence, we all know each employee is registered as an employee at these facilities. That exchange that happens, you no longer are even allowed to be in possession of those plants too. So this provision gives us 30 days to have those people either bring them into the facility, pass them off to their patients in compliance with the MMFLA, or destroy them in compliance with the MMFLA. And I think that choice is the one that's least palatable. So this is our conversion. And while it might not be perfect, I don't expect that we're going to see, if you're doing it compliantly, enforcement issues. And I think that that's sort of the area of how do we propagate this market without these, crossover concerns between the two acts.
Right. It's the same way that a caregiver can provide seeds under the previous draft and now seeds and seedlings to growers. The MMFA of 2008 does not say you can do that. The MMFLA says you can.
Right.
So that's the same way a caregiver doing that. If you only look to the one law, it would look like it would be not allowed. However, the specifics laid out in the newer 2016 law allows you to do so.
So we've only been doing it in the context of growers for part of this conversation. And the other part of the conversation is for processors. So processors are given the same kind of opportunity for 30 days after the issuance of your license. So this little window, and it ends on December 18th. I'm sorry, December 31st of
Right.
2018. So everything we're talking about these marijuana plant transfers and getting out of being a caregiver into one of these facilities and keeping your plants ends at the end of the year.
Yep.
So if you're thinking about, well, I'll just wait another year and then I'll join a facility,
It puts
you
a
lose your
deadline on,
plants.
yeah. So if you want to be a grower and you want to rely on the plants you might already have now as caregivers or as a member of your teams for caregivers, you better be working on getting your license, because if it takes too long, your municipality drags its feet. The state's indicated it's taking a couple months to process these licenses. If you're not able to get this right started prior to December 31st, 2018, you're going to have to purchase plants from other licensees, other growers, and things like that.
Yeah, that's correct.
And just so you know, Rick, all of the details we're talking about laying out in this bill, you're right, aren't going to be allowed until the governor signs the bill.
Yeah.
So we're just contemplating it because it seems like there's such support behind it; it's almost an inevitability. But in the event that this bill does not come to be, you can't take advantage of the things laid out here.
Right. So again, remember we said at the onset, this is on the desk of the governor. And we're presuming it, but the specific language we're talking about is in Section 501, Section 7, where it says up until December 31st, 2018, for a period of 30 days after the issuance of the license, a grower may transfer any of the following that are lawfully possessed by an individual formerly registered as a primary caregiver, and that includes the language of marijuana plants. And then when we flip over to 502, there's sistering language in Section 4 of the processor license. So we were just about to kind of dovetail into that. And I think, Shane, this might get back to the question that you were answering before, or asking before, and that is, how do these extraction processes get into these dispensaries? I think that was the general, comment that you were asking about. And I was just flipping it to see a bunch of extract products. First and foremost, we have to remember the dispensaries that are open today are open as medical marijuana caregiver centers under the old MMMA.
Yeah.
So there are restrictions in supply, there's restrictions on who's allowed to transfer to whom, and if they're staying compliant with those laws, then they're never going to have an extract product that was not produced by a caregiver in a way that was legal under the MMMA. Mm-hmm. Saying that all the way through, though, that was always a challenge.
Right.
So it really what we're talking about is where we'll be in the future. These licensed facilities, licensed processors, licensed growers, and licensed provisioning centers, and the maturity of the MMMA into the MMFLA. So what we see before and what we've seen on the shelves, a lot of those products, many of them may or may not be in the market as a brand in the future. Right. None of that's promised.
It's important to remember that as of today, there is no one with a license that's been issued by Laura under the MMFLA. Right. So we're really talking about how these new businesses that are currently seeking licenses are going to have to operate and what the rules for those licensees are. Anyone that's currently doing something out there, hopefully they're doing it legally under 2008's Medical Marijuana Act, but that's the rule that's applying to any activities currently happening today, unless you're in a temporary operating situation.
And Don, it gets to your question, too, about overages, and you will not hear that Travis or I are going to be of the opinion that that's an activity we're going to be advising you to do. There's gray area there, and we're going to stay out of that for the conversation. In the future, dispensaries, which will be known as provisioning center licensees, are only going to be able to buy supply from a licensed processor or a licensed grower, period, end of statement. So anybody who's just a caregiver is not going to be able to sell their product into that market stream. What they can do before the end of the year is join the licensees, become an employee, and have their supply and their genetics and all their work come into the licensed facility and be part of their product line to be sold to dispensaries.
Right. And a grower is a plant cap. So if a grower is able to grow thousands and thousands of pounds of harvested materials, there is no usable marijuana cap on a state licensed grower. So they only can have a certain amount of plants at any given time, but if they happen to be really good at harvesting large batches, they can have huge piles of weed. Unlike a caregiver or a patient who can have 12 plants and no more than 2.5 usable ounces of marijuana at any given time.
So let's dovetail back over to processors. So now processors, like a grower, are going to be allowed to use that 30-day window to buy actual plants from caregivers who are hired in to be employees at the processing facility. And so that, again, gives us the opportunity to maybe say we can take these, these plants that may not have been harvested for several months and bring them into a facility that a grower or processor licensee can purchase from those caregivers as an employee, bring it in. They're buying it as part of their, the capitalization to get their businesses going. now they can maybe have, again, supply opportunity, because if
Right.
you were waiting for a tagged seedling to turn into something that's harvestable and sold from a grower, again, we'd be losing at least half a year of time.
Right.
And this law technically fixes that for us.
Just like a grower can have a plant that's ready to be harvested, a processor can bring in a plant with all the trim and flower still attached to it and pull that all off and start.
Or use the whole plant.
Exactly.
I mean, a lot of
I don't know.
a lot of processors might use the whole plant, some
Right.
use trim and
So,
cuts.
but effectively, they can start with that and not even necessarily have to buy it from some grower who's also working on getting their license.
So the next fix that I think is important and that we keep talking through is what happens for secure transportation. We said at the onset that that's a major technical fix that occurred. In other words, if you're co-located, this fix would say that you don't need a secure transporter to just move it within your building.
Correct.
As long as you have separate designated areas, you might even have a garage port door between your process and your grow sides. You lift it up, you bring your supply through, the grower's obligated to report the transfer on metric. The processor's obligated to report the receipt of that product on metric. And the system is something that is auditable at any time. And I would expect that if you are co-located and you are doing that, enforcement might come in just to audit those numbers and make sure that, as you say, your supply moves through the supply chain, that it actually occurred. Outside of that, we don't need to have it verified by the transporter the way we thought it would.
And let's be very clear about what you can do when you're co-located. It states specifically, you can transfer using only private real property without accessing public roadways. So public roadway is not the same thing as other means of connecting to buildings on the same parcel or two separate parcels. Depending on your layout, it's all about what types of access you need to move that material from point A to point B. So you might be in a big building that has two sub-units in it. You might be in an industrial cul-de-sac that's a private driveway with no road associated with it, moving it, on a wagon from one building to the next, or whatever it ends up being, or a truck, or whatever you're using.
Right.
But
Stagecoach.
Exactly. Or a backpack, whatever. But the minute you need to touch a public roadway, you have to have a secure transporter. So even if you're across the street or next to each other with no real, connection point or a business in between you, even if it's a short distance like that, unfortunately, you'd have to use a secure transporter.
So, and this is another area where the change is actually helpful too. And it says a grower may only transfer marijuana plants by way of secure transporter. But then it goes on to say that the grower license authorizes sale or transfer of seeds, seedlings, and tissue cultures from a grower or to a grower from a registered primary caregiver or another grower without it. So in other words, the secure transport is really designed to be for plant harvested, supply chain side of it. If you're talking about propagating side of it, how do I get new seeds? How do I get tissue cultures? How do I get seedlings? Maybe clones that remember, as long as they're less than 8 inches, they're not tagged. And so that opens the door to that part of the transfer before we get to a point where we have plant counts that really are more finite. As we go back through the transporter part of it too, and we've been talking a little while, so we'll just keep moving along here. As we go and look at it, there's some questions too about, well, what about a safety compliance tester? Like, how do we get product? Before we'd have to actually have the transporter pick up what could be literally 3 grams of marijuana at a grower facility and take it to a safety compliance lab, and then bring it back to the grower so they can add it to their harvest and sell. This actually fixes that as well.
Mm-hmm.
Yeah. So
effectively, it allows the safety compliance facility to go obtain and then return with the sample size from processors, growers, and provisioning centers for testing purposes.
Yeah, so in essence, they'll have their own kind of delivery and pickup service. And I think that is clearly something that will help the whole market as a whole. Number one, why would you want to pay the cost to a secure transporter?
Number two, why would you train a secure transporter to know what they're obtaining if they have no idea what they're doing? And then the scientist that knows what they are, or someone they've designated.
And the other language in here too says collect a random sample. So now instead of me being the grower saying, oh yeah, test this part right here, put on the secure transporter, and it ends up at the testing lab. Now the testing lab shows up and they look around and they say, all right, I'm going to pick a little bit off of that flower, or I'm going to take out of that harvest bunch or bundle. And so now they get to randomly select those.
And put yourself in the shoes of that testing facility, right? You have an obligation to maintain your reputation. So if you approve a batch of harvest because somebody told you totally test this part of it, and it comes to light that batch when it's sold has some issue with it, and you were the testing lab that signed off on it, you're going to not want to be in that position. So having the ability to go make sure you get the appropriate amount you need from part of the batch that you might be observing to ensure that your test is going to be accurate kind of puts that into a more objective position. That lab wants to be finding anything it can find for issues, and if they have a little bit of stake in making sure they get enough of what they need or from the right part of where that batch is in its lifeline, it's going to make sure we have better testing overall in our system, safer for the patients.
Absolutely. And the one caveat that's important about all that as well is that when they're done testing it goes back to the facility they picked it up from. So they can't pick it up at the grow facility and then drop it off at the processor provisioning center. It's direct bilateral back and forth transaction. And now what we've done is we've taken another cost out of the marketplace that was going to be borne on the patient and buyer and kind of clean that up in the middle. And I think we're going to see that so that properly situated co-located facilities, and through their testing, even between it, because we know that a grower has to test it before it can even go to the processor side. Well, they're getting that gram back, and then they can take it across the door wall. So this is going to actually take some burden off all of the operations, and I think it's designed also maybe to some degree to prevent the logjam that might occur while people are waiting for transport and those kind of things, because we can deal directly with these facilities now.
Or geographically, depending on where you are in Michigan, there might be a lot of access or it might be less. So it'll just help smooth everything out.
Yeah.
Speaking of transfers, I think we glossed over this, but one of the other changes both for growers and processors is the ability now very clearly to move plants from grower to grower and process materials from processor to processor.
If you're really good at making butter and you just want to just make butter, and somebody else wants to just be a bakery and not own all the extraction equipment and have all the necessary facility requirements for that, those high-end, extraction machines. Now you can be a niche bakery and just buy extracted product and infused product and use it in your baked goods. And so it's actually going to create a true opportunity for mom and pops. Remember, that was something that we really, we hear a lot of concern about. People are going to be pushed out of this industry. Well, if you're really good at making a cookie or a brownie and I'm using that kind of loosely, a specific kind of edible or even a specific kind of vapor pen, and you have the machining equipment needed for it, and that's all your license, that's all you want to do is be in that little lane of the area, there are going to be wholesaling companies now that can provide you high-end raw material, and this law allows for that. And so from the work group, from the processor work group, we're really excited to see this kind of change. It was a big part of our conversation for where rules will go.
And just, analogy to that, as a grower, if I have a grow facility I've established on the east side of the state and I want to set one up on the west side of the state, I can transfer my plants via a secured transporter from my current grow operation to my new one. Right. Or a third party might want to get started out and buy some of my plants that I have.
And so, again, this is just giving a lot more latitude. It's really allowing the maturity to occur in this market without boxing out all the little guys and little women that are looking to be in this facility, without having to have multi-million-dollar facilities. Right. I think this is really going to open the door to see some really cool niche type of
if you have things. Something you're really good at, this gives you the flexibility to, focus on that. If I just want to have the economy of scale to do nothing but mass produce, THC oil or CBD oil, and then, instead of selling that to a provisioning center, there you go. A processor can have 4 or 5 steps in it, maybe. Who knows? It adds that flexibility. We'll let the market mature. We'll let these different businesses succeed.
Yeah, and it's really exciting to see how the people's creativity can come out and not be restricted by the need to purchase unnecessary equipment to get that done. Diane, you asked a question about being a felon. The answer actually is the question's a little too broad to say a yes or a no to. The Act does limit the opportunity for a license to somebody who's had a felony within the last 10 years.
And similarly as an employee as well.
Yeah.
But the level of scrutiny depends on your level of control or ownership into the company.
Right.
So the rule of thumb is if you've had a felony in the last 10 years, you're going to have some issues. If your felony is older than that, it's going to come down to other circumstances.
Yeah, if you've improved and done the things that make you a better citizen and all those things, you'll be able to demonstrate that. And so that is something that they're not allowing. The people that have had prior past felonies will have an opportunity in the industry eventually here in Michigan, but that 10-year window is what we're dealing with today. It says I have a caregiver status and I own my own closed loop and fractional system as well as van. Can I continue?
Yep. Nothing's changed for caregivers and patients. 2008 remains intact. If you're operating legally under 2008, you can continue to do so. Just remember, it's one caregiver to 5 patients, 12 plants per patient, 2.5 ounces of usable product per patient.
Right, or as extract goods, you have limits on your volume
or
for
their
extraction.
equivalents. Yep.
Yeah, exactly.
A great way for overages, just as an aside, 36 fluid ounces of liquid form usable marijuana equals 1 ounce of dried flower. So if you're having overage issues, you might look into converting into liquid-based,
Yeah, and creating extraction product out of it because you can volumize what you have at that point. You can have your own plants, but no caregiver plants if you want to be a grower. So a grower licensee, just so we're talking about apple to apple here, a grower licensee is a specific MMFLA licensee here in the state of Michigan, and they're going to have plant limits of 500,000 and 1,500 plants. And so that's a license that's actually a far greater and bigger license than a caregiver license is, which limits you to 72 plants for 5 patients and limits your supply. A grower license can grow as much as they can out of their 500 plants. So if you want to grow 10 pound per plant plants, go for it. If you're a pound a plant harvester, go for it. But as far as your own plants, if you're a registered licensed caregiver, you're limited to the numbers you have for patients that you're registered for.
And if you become an employee of, or if you have ownership in a grow license, you can't be a caregiver. You have to be one or the other. If you're a patient, that's different. It says you can't be a caregiver. But if your status is caregiver, you have to stop being a caregiver to be an employee. If your status is patient, in theory, you potentially could.
Yeah, and think that there's no restriction between the MMFLA and the MMMA. A patient who is growing for themselves is still going to be allowed to. Nothing changes. It's when you're doing it for somebody else.
Yep.
And I think that's where
they don't want an unregulated private caregiver that's manufacturing marijuana also being involved in a highly regulated commercial manufacturing of marijuana.
So another little nuance to the act, if we may, and this is kind of subtle in there as well, which is a safety compliance facility can actually take a caregiver's plant and provide testing results, and that caregiver then can turn around and look for employment at a facility that they can then bring those plants to as well. So as long as that occurs within this calendar year, that can happen. But the opportunity for a caregiver to test their product consistent with the MMFLA is something that is going to be available to them as an opportunity. So if you're trying to test your strength as a caregiver and show your wares as to your skill sets, this is a way to demonstrate how your plants are doing as far as their health and everything. And that was something that wasn't previously written into the Act. So safety compliance facility as a licensee is going to be able to accept unlicensed, unregistered plants and do testing on it from licensed caregivers.
Another thing to remember, too, is that December 31st, 2018, sunset on bringing plants in doesn't prevent caregivers from bringing in seeds, seedlings, and tissue cultures.
That's right.
So even if you're a caregiver in 2019 and beyond, that doesn't mean you're prohibited from bringing in some of your genetics. You just can't bring in plants. You have to bring in seeds, seedlings, or tissue cultures, pursuant to the rules laid out in this bill.
That's right. And so... I think we covered an awful lot.
Yep.
The only thing that I guess we really haven't touched on, which I think is a little consequence to our conversation today, is there's some changes to the advisory board requirements by March 1st, so a little over a month and a half from now. Actually, a little less than a month and a half. They're supposedly going to have the advisory board named. I don't know how they can because there won't be licensees, but we'll work our way through that, I'm sure.
Yeah. There's also some changes for how a municipality is going to be involved. With what they have to disclose to Laura for the licensing purposes. It makes things a little more clear. It's going to be on a form provided by Laura.
Right.
And then it also clarifies the role a municipality is going to have when you're renewing these licenses.
That's something worthy of talking about too. So, we've been asked in a lot of communities, well, what if we don't like what the facility's doing? Are we stuck just because we said yes? The technical fix actually puts the onus on the municipality now to reaffirm to the state that the renewal of that license is not something that came with violations locally, or that there hasn't been a change locally to the ordinance. So at each phase now, in phase 2, when you're going for your phase 2 approval for your facility plan, you're going to have an attested form from the clerk that's filled out by the municipality, rather than us guessing what it's supposed to say. The form will be given by the state under the new act, and what we'll expect to see from Laura shortly after. Shane, you asked a question about butane extraction at home, or do they have separate places away from neighborhoods? What I would say is this. That's, first of all, the butane is going to be prohibited except within a processor license, right?
Butane cannot be done where anyone resides.
Home, right? Yeah, exactly.
So you can do other extraction methods. If you're going to extract by butane, you have to do it on a piece of land where no one lives on it. It's very highly discouraged, but there are technically ways you can do it.
Right. In a closed loop system, it's obviously safer than in an open loop, but the fear is in residential neighborhoods. They've seen these, obviously these explosions and these bad practices, and so in residential neighborhoods, they're not going to be allowed. And separately, the local community would actually have some opportunity to ban that under the MMFLA, and so we just need to be careful about that.
Those were changes to the MMFLA that went in place in 2016. So they're currently in effect. That you cannot do butane extraction at a place where someone lives.
Right. So outside of that limitation, if you have a facility in a location where the city approves the use in an industrial building or something like that, then that could work. And I'd strongly encourage doing PSI testing and getting getting it set up in such a way as to ensure the local area that there isn't going to be any issue with explosion when dealing with a volatile chemical like that. So hopefully we answered that. We appreciate all the questions today. Got another one here. So boarded for 3 months and I have no access to police. I don't know if that's something we'll be able to answer.
Yeah, if that's truly the situation, I'd encourage you to reach out to.
If you want to reach out to your criminal defense attorney or contact the Barton Morris Law Firm.
The other half of our firm does that, so you're welcome to reach out to us.
We do some criminal work. 248-541-2600.
There you go.
Allow one of our criminal defense attorneys to answer that question and see if there's a way we'd be able to help you with that, Felix. I don't think that's appropriate. The Cannabis Legal Group, we are helping people get their licenses, keep their licenses. The law offices of Barton Morris handles criminal cases if necessary for those kind of clients. We're here to make sure that our clients on the Cannabis Legal Group have the best information, the most knowledge, and can operate successfully. And then, of course, network everybody so that they have the opportunity to sell their product in the marketplace and do it in a consistent way that's safe and secure for our market.
Definitely.
Well, this was a long one, but I think a very robust one. We appreciate everybody's viewing. We appreciate all the questions. We'll be back next week. I don't even want to guess what the topic will be yet, but we'll get to it.
Quickly, too, there is a Laura board meeting.
Yes.
The board's meeting today. I think it's 12:30.
Yeah,
we might get some updates on how licensing's going. I think they're going to be going over some rules and things like that.
I wouldn't be surprised if they covered this a little bit, too, as far as what's expected. So
they usually live stream, so look to their website for that if you want to tune in, or if it's in Lansing, I believe, if you want to attend.
That is right. It's Michigan.gov /medical marijuana, spelled with an H. There is I already was on the page today. You can easily click on that page and go right to the live streaming. So we'll see how our market goes. We're excited to see what comes next. This was a very substantive one. If you have questions off air, feel free to keep asking.
I usually try to jump into the comments later and answer them.
Yeah, definitely. So, we'll see you next week from the Cannabis Legal Group. I'm Craig Aronoff.
Travis Copenhaver.
Have a great weekend, everybody.
See you guys.